Complete Justice vs. Nuclear Missile. What is Article 142 that has been excoriated by Vice President Thankar? Vice President Jagdeep Thankar on Thursday expressed concerns over the recent Supreme Court judgment prescribing a timeline for the President to sign bills sent by the states and voiced his worries about the judiciary performing executive functions and acting as a super parliament. There is a directive to the President by a recent judgment. Where are we heading? What is happening in the country? We have to be extremely sensitive. It is not a question of someone filing a review or not. We never bargained for democracy for this, he said. Thankar also stated that Article 142 had become a nuclear missile against democratic forces, available to the judiciary. 247. The Constitution of India under Article 142 grants the Supreme Court broad inherent powers to do complete justice, ensure justice by filling gaps in the law and overriding legal provisions when necessary, which entails interpreting and applying laws considering broader constitutional principles, societal needs, and evolving standards of justice. Its draft, Article 118, was adopted by the Constituent Assembly without any debate. This meant that demarcating its scope was left entirely to the SC. The court has used Article 142 to quash criminal proceedings, dissolve marriages on grounds of irretrievable breakdown, and enforce settlements in cases like the Bhopal gas tragedy. While its powers are expansive, they are not unlimited. The SC cannot contravene constitutional provisions, substantive rights of non-litigants, or principles of natural justice. Under Article 142, the Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. It enables the SC to exercise executive and legislative functions in specific scenarios, including issuing guidelines, directives, or orders to governmental bodies or other authorities. The provision permits the apex court to intervene in matters concerning public interest, human rights, constitutional values, or fundamental rights, safeguarding them against any form of violation or infringement. It elevates the Supreme Court's role as the protector of the Constitution and ultimate interpreter of the law, serving as a catalyst for judicial activism and innovation. The article is structured into two clauses. Article 1421, it states that the Supreme Court may pass decrees or orders to do complete justice in any pending matter. These orders are enforceable across India as per the mechanism prescribed by Parliament or, in its absence, as directed by the President. Article 1422, this clause grants the Supreme Court the power to secure the attendance of persons, production of documents, or take actions to investigate or punish contempt of itself. These powers are subject to any parliamentary legislation. Over the decades, the Supreme Court has utilized Article 142 for two primary purposes: to do complete justice. It allows the court to bridge gaps in law to deliver equitable outcomes. To address legislative lacunae. It enables the court to act in areas where legislative provisions are inadequate or non-existent. A study by IIM Ahmedabad showed that the SC mentioned Article 142 or the phrase complete justice in 1,579 cases between 1950 and 2023, most of which were civil cases. The study found that the court had explicitly used its powers under Article 142 in only 791 cases. In its first few decades, the SC was especially sparing in its use of Article 142. In Prem Chand Garg 1962, the court had been called upon to examine whether the provision enabled it to pass rules that would restrict the scope of Article 32. A five-judge bench answered in the negative. Speaking for the majority, Justice Gajendra Gadkar wrote that an order passed to do complete justice must not only be consistent with the fundamental rights guaranteed by the Constitution, but it cannot even be inconsistent with the substantive provisions of the relevant statutory laws. But as the court got busier, there were more frequent invocations of Article 142. In Delhi Judicial Service Association 1991, the top court noted that its powers under Article 142 were entirely of different level and of a different quality. It added that prohibitions or limitations contained under ordinary laws could not restrict its constitutional power under Article 142. Later that year, the court echoed the same view in Union Carbide, while ordering the chemical company to pay $470 million as compensation to victims of the Bhopal gas tragedy. In Vinay Chandra Mishra 1995, a three-judge bench held that Prem Chand Garg was not good law. Article 142, the bench said, was constitutional power that cannot be limited or conditioned by any statutory provision. In Supreme Court Bar Association 1998, a five-judge bench held that Article 142 could not supplant the existing substantive law applicable to the case. In State of Karnataka v. Umeda v. 2006, the court held that it would not grant any relief under Article 142, which would amount to perpetuating an illegality. However, in 2017, the court used Article 142 to ban liquor sales within 500 meters of national highways. In May 2023, a five-judge bench exercised its power under Article 142 to recognize irretrievable breakdown of marriage as a ground for divorce under the Hindu Marriage Act. This paved the way for a no-fault divorce jurisprudence, despite the ground not existing in personal laws. The court then relied on the provision in 2024 to set aside the mayoral election in Chandigarh. With the use of Article 142, the Supreme Court this month cleared stalled bills passed by the Tamil Nadu Assembly twice, and also rendered the action of the President void. The President had assented to one of the bills, not considered two, and rejected 7. Judicial overreach. Critics argue that Article 142 sometimes leads to judicial overreach, with the court encroaching on legislative functions. Swipe left for next video. Subjectivity. The discretionary nature of Article 142 decisions can result in perceived inconsistencies or bias. Impact on lower courts. By quashing or bypassing proceedings in lower courts, the Supreme Court's actions under Article 142 may undermine judicial hierarchy. Latest blogs.